No, he's terrible. That's a uniquely affordable little scratch. There are these things in life that come around like one thing, where like elections, I'm sure you're gonna do this. They have a thing strong. And then, yeah, he's not working. So you talk for you one day. And then we have 6 people. Not supposed to be. It's really you for that. You stay long enough, you get around. Are they gonna be, I know they're late. They're gonna be. They have a. So if Batman, we know some all these. And jump on a lot, yeah. That's down. Still another. Yeah, I don't do it. Yeah. This guy. Well, what was there to learn? I started on either. Yeah, you start on Thursday. You go to my oh, okay. Oh, cool. So where's everyone? You made, yeah. All right. Board of Appeal and the Board of State of Florida is now in session. Honorable Dan Fricker, Chief Judge, presiding. All persons having a business before the court shall near to that something can be heard. May God save the United States of America, the state of Florida, and the honorable court.
Thank you, Marshall Crawford. Good morning, everybody. Welcome to an oral argument session of the 6th District Court of Appeal. I see we have a packed audience today, but we are being streamed live on YouTube. To that extent, if you haven't already silenced your cell phones, I would be grateful if you did. My name's Dan Traver. I'll be the presiding judge today. I'm joined to my left, your right, by the Honorable Roger Ganem, and opposite to my right, your left, by the Honorable John Stargell. We have one case on the docket this morning. It's case number 23-1205. Keith R.E. Johnson and KREJ Leasing Inc. versus Keith Garrett. Mr. Brownlee, will you be doing the argument? 5 minutes for rebuttal is standard. Would you like more or less? When you're ready.
May it please the court. Good morning, Your Honors. Mike Brownlee here on behalf of Keith Johnson and KREJ Leasing Incorporated. Your Honors, we've got a lot of issues going on appeal, and kind of how we did it in the reply brief. I think it's the best use of the court's time and this oral argument time to focus on what I think is our best argument and the cleanest argument for this court to reverse on. And that's the lack of individual liability of Mr. Johnson. And obviously that's a paramount concern to him. Our position is that there's simply no basis in the record to hold him personally liable on the jury's verdict. Now this all starts with a ruling really early on in the case on partial summary judgment ruling. And the trial court found that there was a non-delegable duty on behalf of Mr. Johnson solely because he was the property owner. Full stop. And it was based on this Ramada decision from the 3rd district, which simply does not apply to the situation we have here, where we have an individual who has a separate leasing company who leases property to a tenant. That is not what was going on in Ramada. In Ramada, we had the same owner of the property acting also as the controller and possessor of the property. And I hope we know by the end of all this briefing, the pivotal, really dispositive question for liability for either Mr. Johnson or KREJ is the extent of control.
Yeah, I want to ask you about the footnote the judge put in the order where he talks about the identity of interest between Johnson and KREJ Leasing. Most LLCs, many of them single member LLCs, have almost identical identity of interest. The court doesn't point to anything here that shows us what he was thinking the difference, or the identity of interest would be between the two of them. How would you, well, what I want opposing counsel and you to address for us are the distinctions throughout this case between Johnson and KREJ. I know you just want to talk about Mr. Johnson, but
Sure.
I want to jump to the next point, which is KREJ and both of them.
Understood.
So as you're going through this, what is it that Mr. Johnson, I understand your position is he had nothing to do with this at all. He just signed as a corporate representative
Correct.
on the lease. Nothing else.
Correct.
KREJ, let's talk about them for a little bit.
Okay.
Tell me what their involvement was when you're talking about the non-delegable duties.
Sure. So I mean, they're a separate corporate entity, right? And there's, the case law is legion that says, you don't lightly disregard the corporate form. It's separate from the individual. There was no pleading or even really effort to establish through proof that there was an alter ego, that KREJ was an alter ego, or that there was an abuse of the corporate form, or anything of that nature. I mean, it was just about as standard as it gets. This is a separate.
At the trial level, they filed 2 separate summary judgments, one against Johnson, one's at KREJ.
Correct.
Was there any request at that point by the appellee to disregard the corporate status?
Absolutely not. And that's a good question, because it shows that these two are being treated separately as they should have been at the beginning. And if you look at the argument as to Mr. Johnson individually, it was squarely on this non-delegable duty ruling. There was no question about, no inquiry even about control. Did you have control over this place or the tenant's activities there? There's nothing like that. It was squarely on this non-delegable duty based on Ramada. Whereas KREJ, there's more of an emphasis. It's different, right? Because you've got to look at the lease provisions in that for as far as KREJ goes. Am I answering
Yes. No,
answering your question?
So yeah, talking about Ramada. In Ramada, you had someone operating the property and they're the ones that hired the security guard.
Correct.
In this situation, what involvement did your client have?
Zero. And not only did Mr. Johnson have zero, he's even a further step removed. KREJ had no role in that. The tenant is the one, I mean, and it is undisputed, everyone's testimony in the record from the tenant's manager, Mr. Searer, who ran day-to-day operations there. It is, I mean, 100% undisputed. They had nothing to do with hiring that security company, nothing. And Mr. Johnson's even a further step removed from that. It's so, yeah, our position is that there's just, both KREJ and Mr. Johnson are simply too far removed from anything that was going on that premises. And if the court will indulge me, I want to just read, at the risk of boring you, but I want to read a quick passage from Bovis, which is the 5th District Court of Appeal case, which is kind of the seminal case on what you look to in premises liability cases.
Before you do that, what's the relevance of a slip and fall case like Bovis in this sort of context?
My position would be that it should be apples and oranges. I think in negligent security cases, and there are some cases that touch on this. There's an Armiger case that Judge Altenburn writes from the 2nd DCA that sort of conflates them and says there really isn't much of a difference. I think that that's not right. I think that in a negligent security case, and even in premises liability cases, what do you look to the right of control? It's the control over the instrumentality that's an issue, right? So if someone falls off a ladder, right, it's who had control over repairs. If, and so same logic should apply in a negligent security case. If the question is, was negligent security the cause of someone's injuries? The inquiry should be who had the right to control security and who had the right to control access by third parties, bad people coming into the premises. So I think it should be different for negligent security cases. And there are a lot of cases like the Basha case from the 2nd District that we cite, and I think Narvez is another one. They do sort of without saying it, they implicitly, I think, deviate a little from the standard negligent or premises liability, slip and fall, those sorts of cases. It's unclear in the case law, honestly, but Judge Schraber, it's hard to, there's a different analysis applied negligent security, but no one really talks except for that Armiger case about why they should be different. That helps answer your question.
The common element here is that the lease controls, because you have in both of, like the Ramada case, all the others. I mean, Ramada, you had a bad actor that was a hotel clerk, and that's where they pointed to.
Right.
They had control over that clerk. So when we look to the lease here, as opposed to some of these other cases that deal with maintenance and other type of approval of any type of modifications to the property, it's all driven by the lease, correct?
Correct. And in that regard, I suppose it is similar, right? And the analysis should start from what does the lease say about who had control over whatever the problem ended up being. So, the lease is the only right, KREJ, again, not Mr. Johnson, but as KREJ, the only right they retain in that lease is to repair the roof. That's it. So, that's what the lease says. So,
A lot was made at the trial court level about the particular nature of this lease, the particular nature of the underlying deed, which involved a grandfathered strip club. A lot was made at the lower level about the subsequent lease amendments as it related to immediate right to control in the context of a default.
Mhm.
Was there any record evidence as it related to there being a default?
no. And the default, it's, just because look, every lease, known to man, if you default, you get one of the remedies is going to be that you have a right to go control the premises, right? There's a default, usually after an eviction proceeding. Here, the only thing the lease says about, it gives some sort of, right for KREJ to come in and control the premises is if the tenant stops operating as an adult entertainment facility for a certain amount of time, because that runs them afoul of some statutes and county ordinances. But that's not a right to control security. It's not a right to control third-party access. It's not a right to control anything that matters for how the injury happened in this case. It's just different. And I think what happened, that, you know, the two trial court judges are two of the best we have in the state. I mean, they're excellent, but I think what happened is this right to control, it was just viewed as too broad. And I think it was part of the urging it as, Mr. Garrett's urge on appeal. You have this idea that, hey, if there's any type of right to control, you're on the hook for everything. And that's just not the law. There's some case law like
So
Vermont.
your position is in that situation that it's because there had to be an event that led to them to take over before there was any actual control.
Correct. I mean, it's just a good old default, right? I mean, if whether it's failure to pay rent, whether it's failure to keep up your insurance, whatever. I mean, there's, very often, at least, that's a remedy, is that you can go in and take possession of the property. I'm going to go ahead and read the Bovis quote because I can't let it go. I can't let it go.
Your time.
Because it really does. It really frames the issue. So an owner of real property is not an insurer of the safety of persons on such property, nor is he subject to strict liability or liability per se for injuries resulting from dangerous conditions on the property. The crux of the cause of action for premises liability is not the ownership of the premises, but the failure of the possessor of the premises, right? Not Mr. Johnson, not Gary J, to use due care in permitting licensees and invitees to come unwarned to an area where foreseeably they may be injured. That's the analysis that should have applied. That's what should have driven the entire case. And unfortunately, in the infancy of the case, when things were just getting going, there was this one ruling that didn't seem that important at the time that ended up, really snowballing and I think causing a lot of the other errors that we raised in the briefing. Unless the court has any other questions, I'm going to reserve the remainder of my time for rebuttal.
Thank you.
Okay.
Mr. Markman. Good morning.
Good morning. Thank you, Your Honors. Jeremy Markman on behalf of the appellee Keith Garrett, and may it please the court. Let's start with, since this was asked, premises liability and negligent security cases. In Nicholson versus Stony Brook Apartments, it explicitly held in the 4th PCA at 154 Southern 3rd 490 that negligent security cases are premises liability cases. So the analysis with regard to the right to control and Mr. Johnson's right to control stems from that. It starts with the deed. This is a deed restricted property. If this was just a deed that was passed with ensuring that the complete surrender of the right to control went to the tenant, there wouldn't be an issue.
Did
here.
Mr. Johnson have a right to show up unannounced and to take control over the security of the operation?
He did, and he admitted so, meaning he had the right to inspect, he had the right to go in at any time he wanted to, and if he did.
That's not my question, not to inspect, to take over.
Yes.
Say, I'm sorry, this isn't happening right.
Yes, and even his own admission on the record at 4879 or 5171 at 72, Mr. Johnson admitted that if he felt that the place was not reasonably safe, then he could go in and take over.
Right.
And he said not only did he have the right to do that individually, he would be running the place that he would be picking the one that would run it, which is what the deed says, is that
This is once he knew that there was a problem with the operation. If it was brought to his attention that they weren't screening people, there's multiple people shot. So what evidence is that there was anything prior to this incident that he was aware of?
well, Mr. Johnson's sticking his head in the sand and not being aware of anything prior to this incident means that he's negligent. It's passive negligence, but he's still negligent. The real issue is whether or not there's a duty, and that duty means that since he has the right to inspect, since he admitted, and since he's allowed to come in and run the place with an absolute and immediate right to run the place if he felt it was unsafe, if he went in and found that the cameras, like they were not working, if he found that the people weren't checking people at the door, if he felt that there should be a metal detector at the door as opposed to a wand, if he felt the security guards weren't adequate, he had an absolute and immediate right to come in and run the place. Why? In order to protect his property interest.
So let's talk about that for a second. You're saying he had the right to do it. KREJ is the lessor, correct?
Well, that's actually an issue. And really, it's a semantic issue. And the reason it's a semantic issue is it's about the right of control of Keith Johnson individually. So Keith Johnson said that KREJ is his property management company. Okay. According to the lease, KREJ is the landlord. So whether it's the lease or Mr. Johnson's testimony, the practical aspect of that, not the semantic aspect, but the practical aspect is Mr. Johnson set up a company himself wearing a different hat in order to manage the property. And if you recall, this is a strip mall where a strip club is, and there's at least 3 different businesses that he tangentially runs or leases out on this property, the adult bookstore, previously a new dance club that closed down, and the strip club. He always retained the right to control the common area, including the parking area. So if we're talking about access control, the only way that anyone can access the strip club is through the parking lot. Under Earp versus Saunders, which is the Florida Supreme Court case precedential here, it was an apartment complex who had and retained the right to control the common areas of the apartment, even though inside the apartment, somebody was shot and killed. There was no evidence of breaking or entering. There was no theory or no evidence as to how the shooter got into the apartment, but the apartment complex was still on the hook. And the reason the complex was still on the hook is because they retained the possessory interest and right to control the common area. In that case, the parking.
But this didn't happen in a common area, did it?
No, it didn't. But in Earp versus Saunders, it didn't happen in a common area either.
Did he control for Elite? Did he contract at all? Is there any evidence of anything with the subcontract?
He delegated the responsibility for security to the Orlando Flash Dancers. So essentially, whether you believe Keith Johnson, who says, I'm the owner of the property, it's a deed restricted property and a strip club has to be run on the property, I am delegating the responsibility of overseeing the property, including the 3 tenants, to KREJ Leasing. And I'm going to put my other hat on in order to do that. And then I'm going to take KREJ Leasing and delegate the responsibility of the day-to-day activities of the strip club to Orlando Flash Dancers. The bottom line is it's Keith Johnson who, through the deed, says you have to run a strip club and you have to do it in compliance with the Orange County Adult Entertainment Ordinance.
Let me ask it to you this way. What if, as opposed to a shooting on the property, there had been a defect in a pole and a dancer was hurt? Is he on the hook for that?
Yes. And it's just like, say, for example, there's whether it's a defect in the pole or whether it's a carpet that's not maintained inside. He retained the right, either through the lease or the deed, in order to inspect and ensure the reasonable safety. And so if we look at
it to you this way, is there literally any tort that could happen on the property that he wouldn't be responsible for?
If there's the bottom line on this is there a duty? And so if there's a duty to some type of tort, then he's responsible for it. And the reason is,
what's an example of a duty absent an unforeseeable intentional tort that under your theory of the case, he wouldn't be responsible for?
Absent an unforeseeable tort. Okay, good. And that's an excellent distinction because that's what the motion for summary
Just
judgment
asking one
was.
example.
Yep. The example of an unforeseeable tort or a tort that's foreseeable.
What would be an example of a foreseeable tort that he might not be liable for that happened at the property anywhere, anytime under your theory of the case?
There wouldn't be one because he retained the right to control. The right to
And is the
control.
right to control then contingent on default or not?
No. You mean
What's the
default in the lease?
Correct. What's the language in the lease that suggests, other than the obligation to repair the roof? What's the language in the lease that suggests that his right, if not based on the nature of the property interest itself, the obligation to control lest it goes out of business? Where is that?
We can look to one of the provisions, which is compliance with the laws and local ordinances. The Orange County Adult Entertainment Ordinance requires a manager station to be continually staffed. It requires videotape that shows any performance in order to view the customer and the dancers at all times. That requirement stems from the deed, but it also stems from the lease because there's a requirement to
What about the license?
the laws. The license itself. Yes, what
Doesn't
about-
it also stem from the license if you're going to operate an adult entertainment facility?
It's contingent to have a license in order to operate that. And it was Keith Johnson who ensured that the license has to be valid. Now, it was
Is his name on the license?
his name is his name is on the application of the license as lessor in the supplement. It's page 4
Did he
of
put
the
it on there?
license. He put it on there. He said, I'm the lessor.
Okay.
Okay,
What-
individually. But to address your concern particularly, the license, even in the deed,
But
the
who
adult.
does it- I want to go back. Who does it list? Who's responsible on the license?
Oh, according to the
operation.
license application, the day-to-day operations is with regard to Orlando Flash Dancers.
Okay.
And it specifically
Carl
says Willie
Shadrick.
Sear- Carl Shedrick or
And
Willie
Willie
Sear.
Sear.
Yes.
So it just shows him as Mr. Johnson as an owner of the property, correct?
The license application that was filled out by Orlando Flash Dancers shows him as the owner. The supplement says he signed individually as the lessor. All right. Now that's, and realistically, with as many hats as Mr. Johnson wanted to wear in this case, who knows what the confusion was as, because he didn't even know which hat he was
So we're
wearing.
supposed to look past all of the legal obligations of the lease and the license. And because the lease allows him to come in if there is a problem, then that obviates every other legal responsibility from the governing authorities locally to any other, the state LLC. All of that is just a sham.
It's, well, all of that, when it's not, it's a sham, it's that he retained the right to control. So it's not contingent on a default. If Mr. Johnson, in his own assessment, based upon his ability to assess the safety of the property, felt it wasn't a default under the lease, but it wasn't safe enough, he could come in and do it himself. He could hire off-duty security for the parking lot. He could hire off-duty security inside. He could do whatever he wanted to do. There was no provision preventing him from doing that, even if he didn't go forward and say, you've defaulted in the lease. And that's the power that Mr. Johnson had. And specifically in the deed, the Orange County Adult Entertainment License that was held by Orlando Flash Dancers was held in escrow for Mr. Johnson. That's required in the deed. So the benefit of the adult entertainment license was solely for Mr. Johnson. And
I want to switch you off of the facts for a second and
Sure.
talk about the law. Obviously, you tried the case, you know the facts extremely well. This contrast that I see when I look at premises liability cases, slip and falls and trip and falls, which are predominantly the cases that you cite in your brief, although not exclusively. And then the negligent security cases. Is there a way that we should view control differently in the context of those two different types of cases?
no, and here's why. Okay, think of your regular slip and fall, and you've got a pothole in the parking lot. And clearly the owner is responsible for the pothole in the parking lot, whether it's late no patent, all those issues aside, there's a duty there for the owner under a traditional slip or trip and fall case, right? The pothole is crime on the property. That's the dangerous condition on the property, that there is a obligation to put in place reasonable measures to prevent harm. So that's all this is the duty is the same, whether it's negligent security or slip, trip and falls. The breach is the same in that they have to provide a reasonably safe premises for its invitees. And the dangerous condition on the property is either a pothole or it is crime on the property. Here it's crime on the property, and therefore the owner's
Is there
responsible.
a way that a commercial landlord could write a lease to disavow themselves from the wide application that you're espousing?
Absolutely, and that's
How would
why
they do that?
Brown versus Suncharm says that if they completely surrender any obligation to the property, turn the complete control over to the tenant, then they have no responsibility. And that's why Mr.
But do
Brown,
they completely in Brown even surrender complete control of the property? Because theoretically, if Suncharm Ranch defaulted under the lease, and we don't know what that lease said, presumably it's got monetary and non-monetary terms. All commercial leases do.
Sure.
So if there's a default under, say, a non-monetary term, under your theory of the case, how is that not control?
because, well, the only thing that they pointed to in Brown that was a measure of control and they said wasn't enough was the indemnity clause. So specifically with regard to yours, there's another case I cited in my brief that says that purely default is not sufficient. But what we have is we have, as Judge Alvaro cited in the order, and let's make sure we know the initial order granting partial summary judgment on duty was reheard and re-argued many times. So in his in his order denying the motion for a hearing on the duty issue, he pointed to compliance with local ordinances, which is in the lease and in the deed. He pointed to the
Would
restriction on
it
the
be
deed.
weird for a commercial lease to require compliance with local ordinances?
Would it be weird?
Yeah, would it be weird?
No, but what we have.
Would every commercial lease require compliance with local ordinances?
Yeah, well, I don't know if every lease would or not, but I mean, I'm gonna give you, I'm gonna grant you your premise on that and answer it this way, which is in this case, because compliance was a strip club, which Orange County has already said violent crime is foreseeable in their findings of facts under the ordinance. And it gave a list of these are the things you have to do in order to provide safety for the people on the property in order to ensure that those violent crimes that are already foreseeable don't happen.
But don't all commercial leases, for example, that involve parking lots require compliance with ordinances or local regulations that require specific heights and colors to parking stops? So do we write this
But they-
particular affirmance in your mind, basically saying that once somebody commercially leases a property, that effectively any sort of unforeseeable tort on the property, they can't distance themselves with
Well,
by
any,
virtue of their ability to contract?
any unforeseeable tort, that of course they could distance themselves.
So it wasn't my question.
I'm sorry, then I
So
didn't
foreseeable
understand.
tort. It would
Yeah.
be a foreseeable tort, or at least an arguably
Yeah,
foreseeable.
absolutely not. You don't have to go that broad. I mean, that's what they're proposing, and they're saying that our argument is that broad, but under Brown versus Suncharm or the Bovis case that they cited, when you completely surrender your obligation, and complete surrender can include compliance with local ordinances like or national ordinances, ADA compliance. But it is up to the tenant there in order to comply with that. Here, it's not up to the tenant, it's up to Keith Johnson to ensure compliance in order to keep this. Because it's deed restricted specifically for strip club, you can craft this affirmance in this case to say that it's the deed itself that requires compliance with safety regulations from the Orange County Code that Keith Johnson had the right to enforce. And when
But take my example again,
Mhm.
and I hate to belabor it,
Yeah.
and we're just talking past each other. But say you've got a situation where the local ordinance says that you've got to paint your parking stops a bright sort of orange.
Yeah.
Right? And in the lease, the commercial landlord says, tenant, the parking lot is all yours. I have nothing to do with it. But you're going to have to comply with all ordinances. And if you don't, I can default you and come in and take over the property. Somebody trips and falls over a purple parking stop. Liability on the part of the landlord?
not if in the lease, not at first when they tendered the lease, all those things were in compliance, or there was a lease term that said that the tenant had to do it. And there was no right to inspection, and it's not solely the default. The lease itself,
No right to inspection,
I'm sorry,
so they can't even keep a right to inspect or drive by and look at it, stand in the parking lot and see that they're not purple.
not with a right to inspection and repair like under Russ versus Walheim. And that's what Russ versus Walheim says, is that the owner retains that right to repair. If the owner in your circumstance says, if I go in and inspect and it's a purple parking spot and I know that's not in compliance, then I have the right to come in and repair it or make you do it.
Under my example, let's say there's no right to inspect. Let's say there's no right to inspect. Let's say there's no right to access. Let's say it's tenant, it's all yours, except you got to comply with ordinances.
Sure.
So all of a sudden they didn't comply with ordinances. Does the landlord buy that liability?
But under that circumstance, if the landlord has completely surrendered that, and by complete surrender can include compliance with local ordinances, only if those local ordinances and the duty to comply with that is completely on the tenant. In this case, it's not, because Mr. Johnson or KREJ had the right to repair, had the right to inspect, had the right to come in, even if they determined there wasn't a default on the lease, and come in and run it themselves immediately. And also, if it just wasn't running within 24 hours or 23 days out of every 30 days in the month, according to the deed, then he could come in and do it. Remember, it's Mr. Johnson who created the corporation Orlando Flash.
Let me ask you this, you're saying he could come in and do it. He could terminate and kick them out.
Or he could just run it while they're doing it. He can do both under the lease or under the deed. He has the right to do that because he has the absolute and immediate right to enter and run the place. If he wants to sit at that manager station and watch what's going on and run the place, he can do it. If he wants to hire security guards inside the property over and above what Orlando Flash Dancers does, he could do it. There's nothing that prevents him from doing that, and the deed and the lease allow him to do that. So in this case, we're not talking about some broad affirmance that says that property owners are always going to be on the hook for everything. It's
Just trying to hone your argument because
Sure.
it seemed exceptionally broad to me. It
And-
seems that when you start conflating the idea of premises liability for slip and fall and premises liability for negligent security control, doesn't it inherently have to be different? Because in the sense that you're talking about negligent security, you're talking about third-party intentional tortfeasors coming onto the property and shooting people. Isn't that different than a roof leak?
no, because I mean, not under the legal analysis, it's not different.
Well, you
because-
cited a fourth DCA case, which we're not bound to follow.
Sure,
Obviously,
understood.
in the fourth DCA case that you're talking about, it's not a holding, it's completely dicta.
It is, I agree, but
We're outside of
Wasn't it-
statutory law in this particular setting, right? We're in a common law setting.
sure.
So there is an element of policy about this, correct?
Yeah, and if this court wants to take the policy that all owners are protected despite what they put in the lease, including right to repair, obligation to comply with laws, restriction on what you can do on the property. Let me just say this example. If Orlando Flash Dancers all of a sudden wanted to go ahead and run a coffee shop instead of a strip club, they weren't allowed to do it. Mr. Johnson could come in and kick them out, or he could come in and run the strip club himself, and they could do their coffee shop on the side while he's still there. If they wanted to run any innocent business other than a strip club, Mr. Johnson had the power to stop them.
But
If-
if we want to run a coffee shop in our lease premises, our landlord is going to kick us out.
I'm sorry?
Yeah, if we lease a premises, if our court leases a premises and we decide that we're going to convert it from a law office into a coffee shop, can our landlord kick us out?
Not if there's no provision in there saying you have to run a coffee shop. In this, it says you have to run a strip club, both through the deed and the lease. And so Mr. Johnson is controlling the activities on that property and requiring compliance with the ordinances. He's requiring compliance with the safety and security aspects of the Orange County Code. I'd ask this court to affirm.
Thank you.
Please, court.
Rebuttal.
You understand, I think you're onto our arguments and understand everything that we've been trying to convey, which is great. But the level of abstraction in the arguments Mr. Markman is making is it's noteworthy. None of this stuff has anything to do with what happened, which I think is what you're trying to say, Judge Draver. And there is an absolute need in the law, in my opinion, from looking at all the vagaries in the case law and how confusing it is about the difference between negligent security cases, particularly with the ubiquity, unfortunately, of shootings and type of violent acts committed by third parties, and premises liability, typical slip and fall stuff. If a landlord's retention of a right to come in and inspect, to make sure, something's, everything is up to snuff at the property. If that right all of a sudden is going to keep you on the hook for, the act of a third party to come in and do something awful, whether it's arguably foreseeable or not, man, we're going to have a breakdown in the, basic landlord tenant law, commercial leases as we know it. And I would encourage the court to provide a little clarity if you're going to write the opinion on that, because I think there's a real need for it under the law. Unless the court has any more questions, I'm gonna.
Counsel, I just wanted
Yeah.
to ask, your colleague says that the lease itself provides the right for Mr. Johnson to come in and if he just simply doesn't like some condition or the way they're running the business, to sort of just take that on to himself and run it even alongside them. What is your response to that?
Our response to that is that's laughable because Mr. Johnson is not a party to the lease. So Mr. Johnson has no right to do anything. And in fact, if he came in and tried to do that, let's pretend Mr. Johnson in his capacity as an individual tried to sue the tenant for some sort of breach of the lease agreement. What would happen? There'd be an immediate motion to dismiss. It would be granted because he's not a party to the lease. So let's just take Mr. Johnson out of it. There is not that right in the lease for KREJ. Section 8.3, Mr. Markman just got up and said, keep conflating the two, Mr. Johnson and KREJ said they have a right to come in basically do what you just said. Section 8.3 of the lease says it is the tenant's responsibility to keep the common areas, the parking lots, all of it. And again, it didn't happen in a parking lot, so who really cares? But that's all in the lease. That is the responsibility of the tenants specifically. So I would encourage the court to reverse for all the reasons we've discussed. I hope that answers your question.
Yes.
Okay,
Thank you.
thank you, your honors.
Appreciate the argument on both sides. We'll be adjourned.